All right, so we'll be talking about rental housing restrictions that have been going on for about the last year. And I just need to make an adjustment. Okay, here we go. So the CDC moratorium went into effect September 3rd, 2020. This was really the most substantial. It's a federal law, obviously. Center for Disease Control implemented this law. It had a substantial effect on rent-based evictions affected by the pandemic. So any tenant that could show that they were negatively affected by the pandemic, they would have to sign certain documentation known as the CDC Declaration. If they qualified under the criteria for the CDC Declaration, they would be protected from eviction. We are seeing, and you all are probably seeing the same thing, substantial amount of rent arrearages on a lot of tenants, $10,000, $20,000, $30,000. Tenants have not been paying rent for nearly a year, and they are protected from being evicted. Now, the past due rent is not forgiven. To me, it's kind of a joke, frankly, because as we all know, collections of past due rent are probably liquidate in the 15 to 20% range. Government thinks, well, they still owe the money, and so you're going to collect the money someday. You do have that right to collect the money, but whether you are able to collect it, will be seen. Hopefully so, because there is obviously a substantial amount. The last figure I heard was about $57 billion of rental arrears due to the pandemic. So time will tell to see how that plays out. The moratorium has been extended 2 different times. Initially, it expired, I believe it was December 31st. And then it was extended to February 28th. Now it is due to expire June 30th. We'll have to see if President Biden extends the moratorium one other time or more. Rumor has it that it will be extended through September. There's one indicator that shows that, and that is the CDC declaration form. The most recent form says it expires September 30th. So if that's any indicator, in any indication, we will see an extension of the moratorium. There have been a number of legal challenges to the CDC order. The original case took place in, I believe it was Ohio. That was a few months ago. There was a case in Houston, Texas. Those cases found the law to be unconstitutional. However, the Department of Justice argued that those cases applied only to the plaintiffs in those cases, which makes absolutely no sense. If a law is found to be unconstitutional, it's unconstitutional. Nothing really happened with those 2 cases in terms of terminating the law. However, the most recent case was in the District of Columbia. The judge in that case found the law to be unconstitutional, and despite the fact the Department of Justice argued that it only applied to the plaintiff in that case, found that that was not accurate and binding. It was binding against the government as to all plaintiffs. So currently, the judgment rendering the law unconstitutional has been stayed in that case, pending appeal. So it's possible, depending on what happens with that appeal, that the ruling will be upheld, and we'll have to see if the Colorado courts, the Colorado eviction courts, follow that ruling. So that is a possibility that sometime in the near future that we will have our judges finding that the CDC moratorium is unconstitutional, but that is to be seen. So at this point, the law is still in effect in Colorado. Okay, talking about the CDC declaration. So again, in order for a tenant to receive protection of the CDC moratorium, they must submit the CDC declaration to the landlord or to the court if a case has been filed. When Governor Polis issued an executive order in the fall, he required that landlords provide the blank copy of the order and a Department of Local Affairs letter along with eviction notices. However, that law is no longer, or that order is no longer in effect. So when you are serving your eviction demands, you do not have to provide the CDC order and declaration any longer. The caveat is, or the exception is, I believe in Boulder County, they have an administrative order that is being updated, but the last I saw in Boulder County, you are required to provide the CDC declaration in both English and Spanish. To reiterate, the declaration only protects a tenant from eviction if it is a rent-based case. The declaration does not protect a tenant from eviction for non-rent issues. So these would be behavioral evictions, lease violations, such as too many occupants, disturbances, unauthorized pets, for example. It also does not apply to non-renewals or termination of a month-to-month tenancy. We have had some arguments that if the tenant is behind in rent and you are non-renewing the lease, that you are in essence terminating based on the rent issue. However, we've been successful challenging all or defeating all those challenges in our court cases. So again, to reiterate, the prohibition only applies to rent-based cases. Now, even if a tenant submits the CDC declaration on a rent-based case, the landlord has the legal right to challenge the truthfulness of the declaration. Kind of varies by county whether the judges are entertaining the challenges. For example, Denver County really is not entertaining challenges, or in just very limited circumstances. However, other counties such as El Paso County, Arapahoe County, Jefferson County, we have had a lot of success in challenging a CDC declaration where the tenant submits that and is trying to get the protection of the court. So issues that come into play in challenging are proof the tenant has income and is still not paying rent, tenant is making other large purchases, new cars, things like that. And as I said, Denver County is very difficult to win challenges, but other counties are more amenable to listening and granting our challenges. Now, you might ask, if you have served a demand and you receive a declaration, are you foreclosed from filing a case? And again, it kind of depends county by county. Denver County, and it also depends by the courtroom. Denver County, they are dismissing cases if there's a declaration, excuse me, and you would be able to reopen the case at a later date. Other counties, such as Arapahoe County, even if there's a valid declaration, the courts are entering judgment, and when the moratorium expires, we will be able to exercise that judgment for eviction. Okay, so that's it on the CDC order. There have been a number of governor's executive orders. The most recent order was signed about 3 weeks ago, kind of came out of the blue, or not kind of, it absolutely came out of the blue. And that was requiring for a month-long period that all rent demands must be a 30-day demand. So this was signed April 20th, and it kind of caught us out of, came out of left field. The governor in his order stated that the funding that's available for tenants was slow in being disseminated to the tenants, and so he thought there were evictions that were taking place that would not otherwise take place. And so he issued this order. Again, it was April 20th. So it requires any eviction rent demand that is served on or after April 20th for 30-day period be a 30-day demand as opposed to a 10-day demand. It only applies to rent cases. It does not apply to compliance cases or substantial violation cases. And so today is the 14th, and we will find out here shortly. It's possible that he extends the order, and we will have to see. Now, at this point, because we're only 6 days away from the expiration of the order, if you have not served a rent demand, I would not do so. I would wait to see, because if you serve a 30-day rent demand now and the order is not extended, you would be better off waiting to see and then serving a 10-day, assuming it goes back to 10-day. If he extends it, well, then you'll serve a 30-day. But at this point, if you've not served a rent demand, do not do so. Wait another week until the end of next week, and we'll see if he extends the executive order. That's number 88 or not. The other lingering executive order was a prohibition on late fees. That was extended a number of times, 30-day periods. The most recent extension of the order expired April 28th, and the governor did not extend the prohibition on late fees. So as of May's rent, you are entitled to charge late fees. The late fees will only apply for May's rent and after. You cannot retroactively charge late fees for any rent, any late rent prior to or balances prior to May. So late fees going forward, beginning with May's rent. So that that prohibition on late fees has expired. So at this point, that is the only executive order that is in effect. Okay, the next issue to discuss is the CFPB advisement. This again came out of left field. The CFPB is a federal organization, Consumer Financial Protection Bureau. They deal with protecting, just what it says, protecting consumers. Now, the CFPB requires debt collectors to notify tenants of their rights under the CDC moratorium. Now, you might ask, well, am I a debt collector? You are not. Case law and other legal authorities say as a landlord or a management company or an attorney for a landlord doing an eviction, you are not a debt collector. However, the CFPB says that, well, that doesn't count. All this other, these legal authorities do not apply, at least temporarily. And so we are debt collectors. And so when you are serving notices, eviction notices, you are required to put the tenants on notice that they may have rights under the CDC moratorium. There is specific language that you must include in your eviction notices to make sure, to ensure that you comply with the CFPB requirement. You do not have to serve the CDC order and declaration with your eviction notices. We talked about that earlier. You do not have to provide those to your tenants. You certainly can, but you do not have to. This is the language that you need to have on your eviction notices. These, and it's only on the rent demand. We have this available on our website if you need eviction notices, but you can read it there. We've printed that or inserted this on our eviction demand at the top in bold text. And so if you do not have this language on your eviction demands, you need to do this until this order is terminated. So that is under the CFPB. Next. Okay. This one's a little confusing. CARES Act was the original federal law that provided protection for tenants in rent situations. It was signed at the beginning, March 27th, 2020. It expired July 24th, 2020. It protected tenants from eviction in rent cases who were negatively affected by COVID. It applied only, or it applies only to properties with federally backed mortgages. It also applies to federally subsidized properties. It applies to tax credit properties. It also applies to Section 8 units. So now, again, the law expired July 24, 2020. However, we came to learn that a couple of counties, Denver County and Weld County, are under the belief that the law is still in effect. So what that means, if you have a property in Denver County or Weld County, and the property has a federally backed mortgage, or this would, I'm guessing this would most likely apply to the audience, either federally backed mortgage or a Section 8 tenant, then you are required to serve a 30-day rent demand. So this has nothing to do with the governor's Executive Order 88. This is under the Federal CARES Act. And to repeat, if you have a property in Denver County or Weld County, you have a federally backed mortgage, you are required to serve a 30-day rent demand. If anyone is interested, if you are subject to this law, if you're interested, we are looking to appeal this interpretation in both Denver and Weld County. This would not apply right now because of the governor's requirement for a 30-day demand. But once that expires, if you're interested in helping fellow landlords with this issue, we are looking for a landlord to appeal these rulings in Denver and Weld County. We would be filing an eviction case. You would be responsible for the charges for the eviction case, but we would pick up the cost of the appeal. When we go back to the 10-day requirement, what we would need is that you've served a 30-day rent demand after July 25th, and then they cured, and now they are in default once again, and then we would serve a 10-day at this time. So if anyone's interested, please feel free to contact me. Again, this will not come into play really until the governor's requirement for the 30-day notice expires. So if anyone is interested, just let me know in the future. I'd be happy to talk to you about that. Okay, so just to review, temporary changes that are still in effect. Eviction moratorium, which is the CDC order, for cases based on rent only. They must be financially impacted by the pandemic. It does not apply to non-rent cases. Again, it does not apply to non-rent cases. So lease violations, termination, lease non-renewals, and termination of month-to-month tenancies are fair game for eviction. Currently, the governor's order 30-day rent demands in all counties. That is per Executive Order 88. That is due to expire May 20th. To be seen whether the governor extends the order or not. 30-day rent demands in Denver County. That's per the court interpretation of the CARES Act. Hopefully, we will appeal that. The scary thing about that, frankly, is that if that is not successfully appealed, that law will go on forever. And the reason I say that is, other than a successful appeal, the only other way for that law to go away is if Congress sunsets the CARES Act, which I think they're doing a lot of other things, and I doubt that would ever happen. So we need hopefully to successfully appeal that in the near future. Other counties, Weld County, this is an interesting one. I mentioned Weld County requiring the 30-day notice, rent notice for CARES properties. Weld County requires 30-day notices for all types of evictions for a CARES property. It's hard to believe, but if you have a CARES covered property and you have a substantial violation, so someone commits a murder on your property, you have to serve a 30-day notice to quit for substantial violation and not a 3-day. So that one is hard to fathom, but that is the interpretation up in Weld County. And then we have the CFPB advisement required on all rent demands, and we'll see how long that is required. But I think once the CDC moratorium expires, then that requirement will go away. A couple other issues. County courts are moving very slowly. Courts are limiting the number of cases that can be filed. Until the pandemic, you could file as many cases as you needed to file. Courts are limiting the number of cases. Judges are slow entering judgments. Legally, you're entitled to a judgment the day of court. Now it's taking judges a lot longer to enter the judgments, to issue the writs. So things are just slowed down, but cases are moving forward. The sheriffs are executing writs. So things are moving forward and hopefully getting back to normal. One last thing I just wanted to mention for anyone that is not aware of this is the ERAP program. This is the latest government assistance program for paying rent for tenants, the Emergency Rental Assistance Program. Our state received $250 million approximately. To apply for funds, you would go to this website here, and there is a process that you would go to and a number of requirements. Unlike prior programs, this program will pay all back payments and will pay up to 2 months of future rent. Payments are sent directly to the landlord. You can apply for rent, late fees, other fees, so utilities, etc. In most counties, landlords can apply on behalf of their tenants. And in order for, or how does the tenant qualify? They must make no more than 80% of the median income in their area. All adults on the lease must apply, including the co-signers. If the tenant has received an eviction demand, that will help move them up the ladder more quickly, moves the application to the front of the line. And part of the requirement is that you can't evict them within 30 days after receiving funds. So they have to be able to demonstrate that they're going to be able to, excuse me, continue to live there for at least another month. If you apply, expect that you can be contacted by the state to verify rent amount, the due date, just verify information about who's living there, etc., and request to stop evictions. You may not get the full amount of rent, but I think they are paying substantially more than the POP program, which was the prior program. So that's all I have on the slides, and we'll take questions now. If you'd like any further information, we've got that tiny URL here if you want to take that down.
Okay, I'm going to go through the chat. So if you guys have questions for them, post them in there. So I'm going to go from the beginning. Wendy, you posted about what about judgment that said it was illegal. I'm going to have you repost your question if you can expand a little bit further, because I don't want to miss this question for you. So they asked about the slides being sent to them after, and I'm pretty sure that we can get that done, right, Vic? We can supply the slides for them.
That shouldn't be a problem. Yeah, just let me know, Andrea, and we can make arrangements for that.
Well, I know I've been getting this question. I've been having a few people contact me, so I'm glad that that this was asked. Do these rules apply for commercial properties?
Which
Like pretty much, yeah, pretty much everything that.
No, yeah, this is only for residential.
Okay. Are there anything special for commercial properties that they need to know?
No, I mean, in the past, some of the orders had applied, but now it is strictly applying to residential properties only.
Okay, so I'm going to expand further on it. So if there's a commercial property and they're not paying rent, so you can give them a notice to vacate, and you do not have to follow what the CDC says on the form.
That is correct. Yeah, okay. The CDC, well, the CDC specifically applies to residential only. The same with the CFPB. The CFPB consumer protection, so it's only applies to consumers, not a business. So under commercial properties are operating under the normal course of business.
Okay. Martin asked if you can address what is the best method of PMs obtaining criminal background checks on prospective tenants, and what are the limitations?
That's a whole, okay. Colorado legislature passed a law limiting the information that a landlord can inquire about and base their selection criteria. I don't have it all in front of me, but that's something we can get. For example, you can no longer consider arrests. Convictions older than 5 years are not considered any longer unless they involve violent crime, kidnapping, and sexual assault. So there's I don't have it in front of me, but that's the gist of it. And just know that there are limitations. No more misdemeanors, for example. So there are limitations. In the past, what your criteria was your criteria, but now it is limited by Colorado law.
And just to add on to that, you just have to make sure that your qualifications are posted, and it's for everyone. So I think he already answered your second part about the no felonies. So he already addressed that about the 5 years. Let's see. We already did the commercial. When was the first executive order on late fees? Did we have to waive all late fees on account that we're receiving late fees on in January 2020? And I know there's another further question, and because there was a gap where, was it just a month, maybe a month or 2 months, where he did not renew the late fee order and he can jump in and charge the late fees, but then he put it back in?
You guys are getting really technical on me here. So the hard part is just to tell you is that there have been so many different orders and law changes and nuances that it's like keeping it all straight is very difficult. The original late fee moratorium went into effect last June. So late fees, any late fees owed prior to June. So this is a year ago now. So keep in mind. Prior to June, and I'd have to double check that, but it's pretty close. So prior to June 2020, late fees could still be collected. After that, I don't believe there were any gaps. I think the late fee moratorium has been in effect the entire time.
And they can't retroact back.
Oh, sorry, go ahead.
And we can't retroact the back, meaning that if they were late in July or December, now that we can charge, we cannot collect those late.
No.
Correct.
Because talk about, say, September, for example, the late fee moratorium was in effect. Just because it's been lifted now doesn't mean you can go back and collect for any of those prior months. Only with May 2021 and going forward.
Okay. Do you need to provide the language for the CFPB when sending out a security deposit disposition when they owe rent? This is when they owe rent.
Great question.
Yeah.
Wow.
Keep you on your toes, Vic.
No, I would say no, because they're gone at that point, right? They've moved out. You're sending the disposition. And so the point of the CFP, having that CFPB language in the demand is that you're saying, look, you live there and you may be protected from eviction. That's the intent. So when you're sending the security deposit disposition, they've already moved. So that would not apply.
Okay. Donna, I think we already answered late fees is late fees, whether they can't pay because of COVID or they just not paying. So late fees, period, you can't.
And then keep in mind, the CDC moratorium specifically says, and the governor's orders say, the tenants are not the rent is not forgiven. They owe the rent. So even if they're protected from eviction, they owe the rent one day.
Okay. Lewis asked if you do Mesa County.
Yes.
Okay.
We service pretty much every county in Colorado.
Okay. Bobby asked, do these laws apply to mobile home lots as well?
Yes, they do. Yes.
Okay. Let's see. Can you please provide a link in the CFPB advisory that needs to be included in any demand of rent? Emily, we'll try to get that put in the chat for you.
Yeah, and if you want, all of the eviction templates are available on our website, and they're just available to the public. You can go on our website and print the forms if you want. Otherwise, we can, as Andrea said, we can put the language in the chat and you can just add it to your form, whatever's easier.
Okay. Susie asked, do these rules apply to owner landlords too, renting their own properties?
Yes.
Okay. Are we required to renew or extend leases to tenants who are covered by the CDC and have received the CDC declaration?
No. And that's a critical point. It's interesting. We're processing more non-rent evictions now than we ever have, because that is in a lot of situations your only option. So again, just to reiterate, the CDC only protects the tenant from a rent eviction. Any non-rent eviction, so it's causing disturbances, over occupancy, unauthorized pets, causing damages to the property, violent acts, drug-related acts, non-renewals, and terminating a month-to-month tenancy. Those are not protected, so you can go forward on those cases.
Great. Jessica, I think we've already answered your question about the dates for the late fees prohibited. Let's see. Wendy, I know you were asking, I thought there was a federal judge that ruled the eviction moratorium was not constitutional. The DOJ appealed that. So
that is correct. So the most important case is the case in the District of Columbia. The judge ruled that CDC was unconstitutional because the CDC does not have the power to enact that order. The judge also ruled that I think it's a female judge, her order applies to all landlords, not just the landlord in that case. So currently, the judgment against the government is stayed pending appeal. So if the judgment wasn't stayed, the judgment would be in effect, meaning the unconstitutionality would be in effect. But since the judgment is stayed, it's on hold, the judgment's on hold. So the CDC is still recognized. The CDC moratorium is still recognized at this point. And frankly, even if the plaintiffs, the landlord, wins the appeal, that case is in a whole different part of the country. And our courts, our Colorado County courts, may or may not recognize that ruling. It's strong authority, but they may not recognize it. So I guarantee you Denver County judges will not recognize it. Other counties may, but it's a moot point right now because we just have to wait to see what happens with the appeal.
Right. And just a quick clarification, commercial does not follow underneath the residential, what you've gone over, but what is their demand? Is it a 10-day or 30-day? Do you know?
No, it just depends. I mean, commercial can have a 3-day.
Okay.
Yeah.
Right. Just really depends what's in the lease, correct?
Correct, for commercial,
Go back to the lease.
Yeah.
So does this apply to multifamily residential, which in some contexts is considered commercial?
Oh, absolutely. Absolutely. Yeah. So if somebody's living there, everything I talked about applies.
Okay.
Even
Pat,
though tax laws could be changing, it certainly applies.
Pat, I think that also answers your questions. Pat asked, are large apartment complexes more than 4 units? Well, I guess it's a different question. Consider residential or commercial?
That's all residential. Again, if people are living there.
Living there, correct. Yeah. Let's see. Did Will County enforce any evictions in 2020? We understand that there were extreme limitations. Did you experience this?
Yes. As I mentioned, when we went through the summary, Weld County has the most dramatic, that may not be the right word, but the most dramatic rulings or interpretations. Most importantly, if you're a CARES covered property. So again, if you have a federally backed mortgage or a Section 8 tenant, you have to serve, and this is aside from the governor's order, but you have to serve a 30-day rent demand, a 30-day substantial violation, a 30-day demand for compliance. I mean, it's hard to believe, but that's what is required in Weld County.
Crazy.
Yeah.
So Angie's asking, if we have a lease ending, do we have to serve a notice to non-renew, or can we just email their leases ending?
Well, it depends. It depends. So by law, a landlord is not required to serve a notice at the expiration of a lease if the lease expires on a definite date, which most leases do. So if the lease expires June 30th, you do not have to serve a notice of non-renewal by law. Now, a lot of leases have a requirement that you serve a notice of non-renewal. So you just have to look at your lease and see what it says. A lot of leases say the landlord or tenant must give a 30-day notice if they want to non-renew, at least 30 days prior to the end of the month. So, so if your lease has that clause, then you must serve a non-renewal notice. How do you serve it? Well, the lease may have a clause telling you how to serve notices. You may have the delivery of notices clause that says you have to email or mail or personally serve. So if you have the delivery of notices clause, then you have to comply with that clause. If there is no delivery of notice clause, then you can mail it, email it, however you want. I think it's even if it's not required under the lease, I think it's a good idea to serve a non-renewal if you're going to non-renew somebody, because I mean, my guess, I mean, a lot of times a tenant won't move out, the lease expires and they think, oh, I'm going to go month to month. So July 1st rolls around and they haven't moved. and now they're trying to pay rent. You're like, well, I don't want your rent. I want you to move. And now it turns into a huge kerfuffle. So bottom line, if your lease requires a non-renewal notice, you must comply with that clause or with that requirement. If it doesn't, you don't have to, but it's still a good idea to send a non-renewal notice.
To piggyback on that, would it be good standard of practice for PMs to then, actually serve that notice, at their door stating that this is the end of their lease? So when that date comes around and they do not move out, now you can use that notice and you don't have to now serve them with another notice to vacate, correct?
Well, legally, I agree with you, but legally, no notice is required. The law says no notice is required. So legally, if they did not move June 30th, you could file a case July 1st.
Okay, so we didn't have to serve.
But the judge is going to be like, well, what's the basis? So we would usually just attach a copy of the lease. But I agree with you 100%. Serve that notice of non-renewal, and then if they don't move, then you file whether it's required or not, and then you file the case July 1st with your notice of non-renewal, and it's straightforward for the judge what as to the basis of the case.
Does it have to be a formal notice to quit, or a standard non-renewal letter on letterhead?
Either doesn't matter. So you can send just a letter, an email, and again, you got to comply with any lease requirements. Mm-hmm. But we have a non-renewal letter available. All you need to say is the name, the address, your lease is expiring, or dear tenant, your lease is expiring June 30th. We will not be renewing your lease. You need to move out by June 30th. Boom, that's it. Now, the notice to quit is a legal statutory notice that you must serve when the lease becomes month to month. And that's kind of a whole different issue. So I'll try to talk about it quickly. When the lease becomes month to month, then you have to serve a notice to quit expiring on the last day of the rental period. So in most leases, the last day of the rental period is going to be the last day of the month. Rent's due on the 1st, the last day of the rental period would be the last day of the month. Some leases have a specific timing requirement, would say if the lease goes month to month, you have to serve a 30-day or a 60-day notice. So let's say the lease says 30 days and it's today, May 14th. If you want to serve a notice to quit to terminate a month-to-month tenancy, it would not be 30 calendar days. It would not be a notice to quit for June 14th or June 13th, whatever that would be. It would be June 30th. So it's a minimum of 30 days if the lease requires 30 days, but expiring on the last day of the month. Now, if the lease says 60 days, you would serve a notice to quit today for July 31st, because you have 30 days of June and 30 days of July. So it'd be July 31st. If the lease is silent, then it's a 21-day notice. So anything up to May 10th, expiring May 31st. Once you get beyond May 10th, then you're kicking into the next month, June 30th. So that would be the statutory notice to quit.
That's awesome. Thanks for expanding further on that.
Yeah, we get a lot of questions on that. And
yeah, that's a tough one.
Yeah.
So you mentioned drug offenses for eviction. Is that just being arrested, or they actually have to be convicted of it?
Okay, so what we're talking about is a substantial violation. If there's a lot of leases will have a crime-free addendum that says if you commit any crime, you are subject to receiving a 3-day notice to quit for substantial violation. So even if you don't have a crime-free addendum, by law, it's implied in every lease that this substantial violation applies. And so by law, a substantial violation is any act that occurs on or near the property that endangers the property or other people. That's the basic definition. And then there's also some more specifics that talk about specific crimes. But what I wanted to get to is that you do not have to have a conviction. You do not even have to have an arrest. All you have to have is proof that someone endangered people or property. So for example, somebody shoots a gun, they call even if it's an accident, they call the police don't show up for whatever reason. But you have witnesses, you have proof that that tenant fired the weapon. What's firing the weapon do? Endangers other people, right? So that is an example where there's not even an arrest, there's no conviction. It's an accident, but somebody endangered other people. So in that example, you'd be able to serve a 3-day notice to quit for substantial violation. Now, drug cases are very difficult to prove. We get calls all the time. Well, I know they're dealing drugs. How do you know? Well, there's people coming in and out. Well, or we found some, white powder or whatever. Well, unless really on drug situations, unless there's an arrest and the police are involved, the police can testify they're dealing drugs. Those cases are hard to prove. It's like, well, I saw this white powder and there was drug paraphernalia. Well, you go into court, the tenant's going to lie. They're going to say, well, that was baking powder, whatever. You get the point. Drug cases, you really need an arrest and probably the police involved to prove that. But the other acts of violence, somebody assaulting somebody, shooting a gun, things like that, don't even need an arrest. If there's an assault, somebody beats someone up, you get the victim to testify, and that would be a strong case for substantial violation.
Awesome. Is there a website that you suggest that we can look at for like the most up-to-date rental laws, moratoriums, late fee allowances, just to keep, and so on, just to keep the PM, up to date on what they can and can't do? Would that be your website or?
Yeah. And so we're obviously landlord attorneys. We live this stuff. We do a lot of webinars. We do a lot of almost on a weekly basis now, just because everything's changing so quickly. But we have a program. It's called our value-added service. Even if you're not really doing cases or giving us legal work, you can still become a client for a fee. And that way you have access to the attorneys, you can attend our classes, attend our webinars, et cetera. So if anyone's interested in that, we can certainly tell you about that.
Angie asked a question, how do we charge for serving of notice? I guess it would basically go back to what we have in our lease, correct?
Correct. It has to be in your lease. So if you're a management company and you're driving around town to serve your notices, I'm totally fine with a reasonable fee. It will need to be in your lease. So that's called we just call that a posting fee. So for posting the notice or serving the notice, that's totally fine, but it does need to be in your lease. If you're multifamily, and again, so for driving around town, maybe $50 a notice is probably reasonable. I mean, it can't be something, outlandish. But if you're multifamily and you're serving notices on property and you send your maintenance guy to do it, maybe, I don't know, $10, $20 for on-site, something like that. But it does have to be in your lease.
Kim asked, how do judges look at notice to quit even when the tenant owns 3 months rent?
Notice to quit, I assume that would be a month-to-month tenant or a non-renewal. We've been successful in all those cases so far. Well, one case in Douglas County, but other than that, I mean, the reality is the contract the lease is expired. Both the landlord and the tenant have the right to terminate, and they are allowing those cases to go forward.
Okay. Do you have a ballpark figure of legal costs for landlord evicting a tenant?
Well, so we do cases on a flat fee basis. It's about, for preparing the case, filing the case, all that's about $500. And the additional cost would be if you need the sheriff to come out, which just depends on the county. It's usually about $100. If the tenant fights the case, then that time is charged hourly for the trial, but ballpark around $500, something like
Okay. When a judge has made the final ruling that the renter owes money, what is the document I file with the county clerk so that when the ex-tenant sells their land home, I'm assuming a judgment, okay, I will be paid before they can give new buyer a clear title. So I'm assuming it's a judgment that they're talking about.
Right. And what are they selling? Well, I didn't catch that. What would they?
It looks like, I guess they're land or home. So I guess whenever they do a real estate transaction, you know,
Oh,
how
got
that
it. Okay, so it's a tenant and then they buy a house. So
right.
you have to, so there are two different types of judgments that are associated with an eviction case. You've got your possession judgment. That gives you the right to have the sheriff put them out if need be. Then you would have a monetary judgment. So once you add up what they owe, you're going to get a judgment for the rent and damages. The average judgment, I think, is about $2,500, but I think they're going to be a lot higher now. So once you have that judgment, that money judgment, then you have to get what's called and I haven't done this in a long time, but you have to get a let me just think about this. You've got to get a transcript of judgment. Give me 2 seconds here.
And then it has
the bottom line is you have to record the judgment with the clerk. Can you help? Are you helping me out here?
Yeah, you have to record the judgment in the county of the property that they bought, they own the property in.
Right. So yeah, thank you. So you record.
Great job, Aaron. Great job.
Brain fade there. Yeah. So you record the judgment with the clerk and recorder. That becomes of record against the property. So against the property that they own. So then when they go to sell the property, title company does title search. They pull up what's a judgment lien, and then that would get paid from the proceeds of the sale.
Awesome, Vic. I really appreciate that. These were great questions. We're going to lead into our next speaker, but I just want to ask this real quick because you're going to, share your presentation.
Yes.
Someone did ask, are they allowed to share that presentation with like their homeowners or anybody? How?
I'll let you know, Andrea.
Okay. All right. Yeah. Okay. Perfect. Thanks again.
Okay. My pleasure. Have a good weekend, everybody.
Yeah, you too. For our next portion of the session, we will be joined by Liz Peets for our legislative update. Liz is the Vice President of Government Affairs at the Colorado Association of Realtors. Liz, all yours.
Good morning, everyone. I am going to start off by sharing my screen so that you guys can see. I just have a PowerPoint about the legislation that we are working on. If I can get it into show mode. Can you guys see that?
Yep.
All right. So I'm going to start off with just the legislation that CAR is running this cycle. We are running what we call the Century of Opportunity package of legislation. It is 4 different bills, and it is targeting us having an ability to spur on the next decade of housing policy. We've been pursuing this in partnership with Habitat for Humanity. Obviously, we call it a Century of Opportunity because CAR is celebrating its 100th year of existence this year. So I'm just gonna touch on the bills that are part of the package. The first bill is a financial literacy bill. So everyone would have to graduate from high school with curriculum about preparing for retirement, understanding credit and debit card use, managing the student loan debt aspect of getting a higher education degree, and of course, as we are very involved in preparing for home ownership. We think financial literacy is important for everyone, but especially our younger students so that they can be prepared to access home ownership. And it also helps them understand when they're renting how to prepare for the next phase. The second bill, House Bill 1028, is a bill that requires the Division of Housing to annually report how much and where we spend our housing dollars, whether that's money coming from the federal government or coming from private sector or state dollars. They would have to, in this annual report that will be made public, so you can access it, you don't have to download it from a legislator. It will tell us how many units of housing are we creating or preserving or rehabbing, and what type of a project is it? Is it rental, home ownership? Is it supportive or rapid rehousing? And we think this data-based approach is really going to help us understand where are we spending our housing dollars and help keep our public officials accountable so that they're looking at all of the continuum. The second, and I guess I should say third and fourth bill is a credit building bill. House Bill 1134 came out of approach this morning, and it will be on the floor sometime, probably not today, but probably next week. It is a pilot program, and what this will do is allow CHAFA as the sponsoring agency to work with landlords to allow tenants that opt into the program from the landlords to report their rental payments that are regularly made as a way to build credit for working towards home ownership, much like a mortgage provides equity. And the best part about the fact that this is a pilot program is we're going to evaluate at the end of the report how it works for tenants, how it works for landlords, because all of the costs of participating in the program, whether you're on the tenant side or the landlord side, are going to be covered. But we really want to evaluate how well it might work in case this is something the state could consider in the future. And we're excited to kind of test out how it would work. The last bill is a menu of options bill, and this is House Bill 1271. So it's going to allocate $13 million in stimulus funds through the Department of Local Affairs, and it will encompass 3 programs. 2 programs are coming from the Division of Local Affairs, and that's the Toolkit program and the Planning program. Essentially, some local governments could get state grants for adopting these menu options in the 3rd phase, the menu phase, but some governments aren't quite ready for that. So they need to start with a toolkit phase, which is the beginner phase. So the division would work with them to do a comprehensive stakeholder process to determine what type of affordable housing measures they might want to take on that meet the needs of their community. This intermediate phase is the planning phase, and that would be hiring a consultant to help you take on a project. And then the menu portion is the CAR portion and habitat portion that we've put forward. And that menu option requires local governments to choose at least 3 of the best practices in affordable housing development, or they could pursue an innovative policy proposal that's off the menu. We're really proud of the fact that we think this program and the menu options here could increase the ability for us to create housing units in the next 3 years. And ultimately, maybe it could become a way that the state funds some housing projects in the future. Again, there'll be reports on all 3 programs, which is very important. But as you can see here in the last part of the slide, what we're focusing on is reducing permitting and regulatory barriers, and also allowing local governments to get some funding to be able to do that. So if you reduce the sewer or water tap fees, or you were reducing or changing your regulations, we want to make sure local governments have the capacity to do that. So that's why the funding is so important, because it allows these local governments to stretch further than they might otherwise, just given the tight budgets after post-COVID environment. And there's also a lot of things dealing with land donation, banking, acquisition, repurposing commercial property for affordable housing, and can you expedite the permitting? Because as we all know, when you're developing housing, time is money. And there's also the zoning pieces about how do we add density into single family zoning in a way that makes sense for the community that's taking it on. So it should be a statewide program that works for both rural, mountain, urban environments. So I'm going to stop sharing just about that package there, and then I will touch on a couple of other bills, and I know my colleagues will also comment. So I'm going to start. I'm also going to share the screen one more time about one of the bills that we've been working on this session a lot, which is House Bill 1117. So this is the original bill that would have opened the back door to rent control. And this bill has been significantly amended, and we're proud of that. So I'm going to show you some of the things that we did in this bill. This first darkened part here is a car amendment that we added to the bill. So what it does is clarify that if a local government wants to open the door to options for developers, they cannot open that door to rent control for existing private residential housing. Many of you guys might remember this as the Town of Telluride case. This is a local control bill overall, and we were afraid that the way it was drafted inarticulately would have opened that door. It has also been further amended, and you can see this double underlined section is a completely new section. This came from the governor's office, but it also works very well hand in hand with the car incentive zoning bill 1271. So what it does is basically kind of put in place some of these considerations that local governments have to take when they're pursuing inclusionary zoning. They have to look at whether or not they are increasing density, whether or not they're allowing more density within a single family lot, parking reducing, and you can see this whole section here really mimics utility charges is another thing that's in the menu, regulatory fees. So this bill is in a much better place than it started off as, and it is now on its way to the governor. I would assume will be signed very soon. So I'm going to stop sharing that one. I also wanted to talk about some of the amendments we worked on in 173 and 1121, but I also want to make sure my colleagues also comment as well. So I'll touch briefly on them and then let them elaborate, and then I'm sure we can answer some questions. One of the biggest things we've been working on is the single family exemption. And this is for 5 or fewer units for single family homes in a lot of the landlord tenant bills. I know one of the questions submitted ahead of time asked, where does the 5-unit exemption come from? It's actually a public official legislative process. So a few years ago, when we were working on a right to cure bill, we were trying to find a middle ground of how could we protect mom and pop landlords. And ultimately, Senator Williams came out and said, I wrote this amendment. Are you guys okay with it? It's 5 or fewer units. And we said, well, we'd be happy to have that exemption. But the number basically came from the senator, and we've been protecting it ever since because we believe it's very important for mom and pop landlords to be exempted from some of the larger abilities of regulation that they can't usually manage as much as someone who has someone that can deal with all these ups and downs of the regulatory cycle. In Senate Bill 173, I know there's been a lot of rounds of amendments, and it was in committee late last night until nearly midnight. 1121's on the floor this morning. The first things that were taken out that we asked for, and several others on the call did too, so they can comment as well. Originally, the bill had trial by jury in it. In 173, they had a requirement that you could remove someone 48 hours after you get a judgment instead of at the court judgment. It also tried to use really what we call one-sided, only on the tenant side type of language. And so when there was some movement to either party, it at least balanced it more on the housing provider side. I wouldn't say it's perfectly balanced, and I'm sure my other colleagues can comment. But that is what we strive to do when we deal with landlord tenant, is try to balance the housing provider and tenant side. I'm going to stop there because I think they would be great at helping us talk about the eviction process and the changes in the 1121 bill, but I'll be here to help answer questions as well.
Andrea, you're muted.
Oh, I'm sorry, is that my cue to jump in?
Nope, sorry. I was talking and I was still muted. This is for Liz real quick. Are fees to landlords anticipated to participate in the credit reporting program if that bill passes?
So the program is going to be completely funded for the pilot. So if you're a landlord or a tenant, it won't cost you anything to participate in the program. What we want to evaluate is what makes sense in the future. I mean, is it hard to administer from the landlord point? Is there a rate at which, if you're a tenant, that you're actually going to participate in the program? Because we also want to make sure tenants actually want to do the program and get their rental payments reported. If nobody signs up, or if folks find it to not be a big benefit, then that's also information. But the pilot part, both sides will be completely covered.
Okay. I'm going to let you answer this one. So with regards of 1271, says this is Amy. She doesn't see the deed restriction mentioned. Without these, all of these incentives and subsidies will only be taken advantage of by developers and not preserve the generations to come. There should be a recommendation, if not a requirement, for a certain percentage based on the locality to be deed restricted to 80 to 120%.
So that's a really good catch, Amy. There is not mentioned a deed restriction, and that is intentional because there are a lot of different housing providers and developers, like housing authorities and nonprofits, in addition to traditional private sector developers that do housing development for affordable housing that don't have a deed restriction method. They have an ability to provide a little bit of equity. Habitat for Humanity is a really good example of that. So what the bill is drafted to say long-term affordability, but we want that to be flexible for the local government in partnering with the creator of housing to work out what that mode of affordability is that they choose to do, so that it makes sense for the local government and it works for the person bringing on the units. But we intentionally didn't specify the method of affordability.
Okay. Thanks, Liz. Really appreciate it. We're going to move on to Danielle Rogers. Danielle joined All Seasons LLC CRMC team as a controller in 2004. She is a current member of the National Association of Residential Property Managers, and she currently serves as the chair of the NARPM State and Local Government Affairs Subcommittee nationally. She is a founding member of the CLLC, which is the Colorado Landlord Legislative Coalition. It's all yours, Danielle.
Hi, thank you everybody for being here today. I'm excited to speak to you all. I want to take a minute and just touch on the CLLC since we are new and some of you may not know who we are. So in 2019, about a dozen NARPM members had a meeting where we discussed that we wanted to hire a lobbyist because we wanted to get more involved and we wanted to see some additional representation for the single family property managers. That's what we're property managers. So that's what we were talking about. We want more representation for property managers. So in 2020, we formed a board and we started to get organized. We decided that we wanted to serve a larger community of landlords and that we wanted individual landlords that are self-managing and investors to join with us. And so the CLLC was formed. We started adding members in October, and we hired our lobbyist, William Much, in November, and we were off and running. So all of us at the CLLC are fairly new to this arena, so we're learning every day. It's been quite an adventure and really a second job to all of us volunteers that are working really hard, but we're really excited about the success that we've had so far. We have about 165 members now, and we're looking for more. So those of you that are here and listening to me today, if you are interested in keeping up, please join us at the CLLC. We need your help. We have participated in stakeholder meetings. We have had members testify both for and against bills this session. And in fact, we had several members testify last night on a Senate Bill 173. And like Liz said, it went to almost midnight. So we had a lot of dedicated people up late and in Denver late and working hard to testify against that bill. And our members have been great at getting out our call to action. So that's the feedback that we're hearing from legislators, is that the CLLC members are emailing their legislators and getting our voice out there through email. So we're really excited about that. We hope to hold an event with legislators and members in the fall. So as a property manager, I just have to say that I found so much value in my business, for my business, in participating in both NARPM and now the CLLC. And so I wanted to take a second and encourage everyone to join NARPM and the CLLC, because NARPM is going to help provide the excellent education and a support network for fellow members. And then the CLLC is here to keep you informed of new legislation and to represent your interests as those laws are being formulated. Because being educated and familiar with best practices and laws is crucial now more than ever. So if you're interested in getting more involved, please reach out to me. We're just starting out and we need all hands on deck. And I am positive that there are people here today that can contribute and can make the CLLC stronger. In regards to legislation, there's a lot going on. Again, the hot topic this week has been Senate Bill 173. It's being called the late fee bill, but it does have a myriad of issues that would affect property managers in it. So it was heard in the Business Affairs Committee last night. At the end of the evening, there was no vote because of the late hour. There was strong testimony on both sides. So now we just have to wait and see what's going to happen there. And then the other bill that the CLLC is tracking right now is the eviction moratorium bill that actually has not been released yet. So it's still in draft mode. And so we have had countless meetings with Representative Woodrow to discuss that bill. There's still some problematic pieces in it. Specifically, there is a proposed second phase, and that second phase is currently set to last from September through January. And so we're going to continue working on that and weighing in on that bill as we move forward. It's been great to work together with all of the different associations, the apartment association and the realtors, as we kind of go forward and try to take care of this housing space that we're all representing.
Thank you, Danielle.
Thank you.
Next, we have Drew Hamrick. He's the General Counsel and Senior Vice President, Government Affairs for the Colorado Apartment Association. He practiced landlord tenant law in Colorado for over 30 years as a partner with Tschetter Hamrick Sulzer.
Thank you. And Liz has been kind enough to run my slides. I appreciate that, so that you're not viewing my Outlook calendar, my Amazon Prime account by mistake. Liz, would you advance to our first substantive slide? And, you know, I'm going to confine my comments initially to the local ordinance changes in Denver, as well as the citizens initiatives that are coming up. And remember, these issues only apply to the city and county of Denver. They are always worrisome because, you know, they're kind of like respiratory influenza. They do tend to spread from one local government to the next. But the one that's probably most on your minds and been in the press the most lately is the newly adopted Denver rental licensing ordinance. This This is separate and distinct from your requirement to be licensed as a broker. Anyone leasing any property in Denver will eventually require to be licensed. And the big distinction between being a licensed broker and licensing under this process is there's no requirement that you're selling or leasing the property for the benefit of another. Even leasing your own property triggers these events. And there is no small owner exception. Even renting a single bungalow in Washington Park that's in your own name will trigger this requirement. The initial application date of this varies a little bit based on your portfolio. If you have two or more units, you're required to be licensed by January of 2023. If you have a single family rental, the licensing requirement doesn't kick in until 2024. There are some economic incentives for early licensing. Basically, the license fee is half the price that it would be by waiting to the bitter end. But I think most practitioners will find they still want to wait because of the inspection piece. Our judgment through the engagement in this whole process has been that it's the inspections, not the licensing, that really adds up as far as cost requirements. On the inspection piece, our primary focus as an organization was to try to carve back inspections to make them only complaint-based. The talking point on that was it doesn't make much sense to spend the money inspecting a unit that has no history or no complaint of violation. Mathematically, what that would work out to is about 1.5% of the portfolio being inspected each year, because that's exactly where the complaint level comes in on these things. What we're able to push to was a requirement that 10% of the portfolio is inspected every 4 years. So there's still the illogical piece there that you're inspecting units that don't need to be inspected. But from a mathematical standpoint, that works out to an annualized inspection rate of about 2.5%. So we're getting close to what we were chasing there mathematically. Where the mischief is done, though, is for small operators, because 10% of one is one and 10% of two is one. So if you're just a dabbler in this process, you don't realize the benefit of that reduction in inspection levels. There is a piece that's required that will be implemented even before the licensing piece is in place. And that is a requirement that all lease transactions be documented by a written lease, which of course is not a very big requirement. I think any of the practitioners on the phone would tell you not to even invite your mother-in-law over for an extended weekend without a brief written agreement about precisely when she's going to leave. But there's also going to be a disclosure of tenants' rights and resources form that's not yet developed by the city, but will be required to be included in a lease. And that always is troublesome for someone that's, not a professional manager, because half the time they don't hear about those types of requirements until they violated. And truly one of the bigger problems with any licensing scheme like this is it becomes a Christmas tree to start hanging other wish lists on. And you've watched that process, any of you that practice in Boulder, as every time somebody gets a wild hair, like residents shouldn't have couches on their porch, or they shouldn't use fireworks, or they shouldn't have large social gatherings, that becomes a lease requirement. And I suspect you and I will see that kind of growth in the Denver ordinance over time. Lisa, you want to advance to our first slide on citizens initiatives? Now, just like we're all familiar with statewide citizens initiatives, people can run local initiatives. One of the real problems with local initiatives is the signature requirements are so low that it's very easy and very cheap to get an initiative on the local ballot. It also becomes really difficult to fight because you've got a limited number of voters you're trying to persuade, and you still have to purchase mass media to do that. It's very difficult to get a tailored message to just the citizens of the city and county of Denver without overbuying. So from a cost benefit analysis, these are very, very difficult and expensive amendments to deal with. There's 3 that are affecting us next year in Denver. Now, they have not gotten their signatures yet, but again, those thresholds are small enough that we strongly suspect that they will. But the first one is really a carbon tax. There's a movement out there to just basically outlaw the use of natural gas. And this is a complicated way to go about doing that. But basically, it would create on all residential property, as well as commercial, although the rates are higher on commercial, a 2-cent per kilowatt charge on electricity and a 20-cent per therm charge on natural gas. Now, by my calculation, that 20-cent per therm works out to about a 40% increase in the cost of natural gas. There is an allowance for basically summer and winter usage, a little bit complicated to go through in this forum, but basically you're given the right to use a little more electricity in the summer and a little more natural gas in the winter. And so these charges only kick in above those below minimum rates, but those minimum usages are very, very low. And most of us will find ourselves paying this tax on energy, regardless of how prudent we might be with managing the thermostat. The electricity piece goes away over time, at least if the grid gets to be sufficiently efficient, the electricity grid. The natural gas charges never go away and in fact grow at 10% annually. So this one is, from just a governance standpoint, horrible governance. But the interesting thing for most of us on this call, including our industry, is we don't have as big of a financial fight in this bad governance because most of these costs are passed on directly to our customers. So to some extent, if our customers decide they want to tax themselves, it becomes their problem, not ours. But obviously for most of us that realize that energy is an important component of all economic activity, we realize how bad this is for society as a whole. Lisa, would you advance that next slide? The secondary initiative that will come up, and the fight to defeat both of these are lumped together into kind of one effort. So you'll see a lot of work and publicity on these two tied together, but they are somewhat different in how they affect industries. But there will be required recycling and composting for all multifamily and all commercial activity out there. The rollout date becomes fairly important because it affects different pieces of us differently. The requirements will hit the larger units first in June of 2022. Units with 74 or more dwelling units or 75 or more dwelling units will come into place. As of 2023, it shifts down to 25 to 75 dwelling units. And in 2024, it shifts down to 8 or more units. Now that's where it stops. So those of you that are in the business of managing single family homes or duplexes, these requirements don't apply to you. Most of your trash collection starts to fall into the normal scope in Denver of residential trash collection, where those fees are funded out of your property taxes and you're not required to have a separate provider. At a minimum, you're required to collect and get to the proper facilities plastic bottles, containers, aluminum cans, corrugated cardboard, and various glass products. For our industry, I think the most, because we've done a poll of our members and I was a bit surprised on this. Roughly 80% of our members have compliant recycling services in place already, and most of them are fairly successful in passing those costs off to the customers. I had always believed that the contamination piece, your trash vendor charging you an upcharge for having non-recyclable materials in the recycling bins, was a lot more severe than it's turning out to be. So the recycle that piece of that works fairly well. Where I think in our industry, you'll see a real problem is this collection of compostable materials and getting that to a proper site, because there really is no proper site for that. It has no use, and it will likely turn out just to be a third trash bin for attracting rats, and will have the effect of raising the cost of trash collection by a third. But this will be the harder of the two initiatives, I think, to come up with a workable message to defeat. Most people hear recycling and they get pretty cozy with that concept. And the polling initially on both these initiatives is surprisingly high. We've seen, thanks to your organization, very extensive polling on these issues. And the one that always strikes me is that more than, I think the exact figure was 71% of the Denver likely voters believe that the current weather is a crisis and something dramatic needs to be done. Don't have a slide on the third one, but there is a third initiative that'll affect many on this line, and that's the Right to Counsel initiative. And that, plain and simply, is a $75 per door charge annually to fund eviction defense for residents. Our estimate is it will create an annual tax on the industry of about $12 million, which is almost exactly 12 times any reasonable estimate of what that service ought to cost. I started doing the math, and it generates something around along the lines of $4,000 in lawyering per Denver eviction. And most of you that have engaged people like Vic to do this task know that's about a $500 task. So it's a really draconian expense in the industry to fund that perceived need. So those were the four items I was tasked to brief you on, and I'll shut up and await an opportunity to weigh in on panel issues. Thanks for the platform, guys.
God, I hate this. I start talking and I'm like, ugh. But just so you know, we're not ignoring your questions in chat. We'll get to them at the very end. Next, I want to introduce, and I'll kill his last name, so forgive me, Nate Baumgartz. He's with ERAP. He is the chair of the legislative committee and has over a decade experience in residential and commercial real estate, including construction, sales, and management. He's currently a principal with Reboot Real Estate Services, a consulting firm focused on small property owners. Nate, it's all yours.
I'm doing well. I don't have a ton to add. I feel like a lot of things have been really well covered by other panelists. The only thing I would mention that we are also tracking, and let me just say, IREM is an international organization, the Institute of Real Estate Management. We provide certification and education for property managers, including sort of the gold standard for the industry, which is the certified property manager. But we also have accreditations in residential property management and commercial. It's a great spot for resources and for networking if you're looking for vendors, or you're looking to learn more about budgeting, or you just want to bring more systems and other things into your business. You're looking to expand that aspect of it. In terms of other things that I think have not been covered, most have been. One thing I'll mention that I think might be interesting for, or we'll see if it's interesting for single family managers, which I think is a lot of the audience, is HB 21 1083, which basically made it possible for Previously, if you challenged an assessment for your property taxes, there was no chance that that number could go up. It could only go down. So it was sort of a free shot to sort of say, hey, you know, I think this assessment of my property is too high and I want to see if I can get it reduced. That's been removed. And given the sort of frenzy and incredible changes in prices of assets in the Front Range area, I think we'll be seeing a lot more of those property tax assessment appeals. And it's important for people to know, especially if you're dealing with owners who maybe are shocked by the change in the value of their property. Their property taxes may go up, and attempts to appeal that can actually backfire and result in them raising the assessment even more. So I thought that was one thing that I hadn't heard come up. Obviously, we're also tracking and very interested in the licensing for landlords, which was passed just early May. That's going to go into effect in January 2022. My understanding is that there's not a lot of clarity yet on what that's going to look like, and who that's going to apply to. But that's definitely something that we're keeping track of, and you'll want to put on your calendar to kind of look at and figure out as they get further into the year. But other than that, I think everybody's covered a lot of important issues. I would say with evictions, the most important thing is just having a good advisor who can instruct you on the right way to do it. They're still going to happen, and we'll see kind of what happens as the moratorium shakes out.
Awesome. Okay, so we are going to move on to some questions that's in the chat. So I know the big one is, and anyone can jump in, is the potential of rent control coming. Let's see, Liz, we'll start with you.
Yeah, so what I would say is the first draft of the bill, HB 1117 that you guys have in your chat, is locks down the opening of the existing prohibition against rent control for existing property. What the bill was targeted at originally was trying to open the door, not just because it was inartfully worded for existing property, but also for new development. And that continues to be the focus of the bill, new development. So I know we would like to have some more guardrails on this, and I know Drew can talk about the guardrails that they've been asking for, but it right now is an inclusionary zoning program, not directly rent control. So usually the way that works is a percentage of units when there's something built has to be affordable, but the new provisions in the bill also have to have them look at density within their land use codes. And so that is a much better bill than it started out being, but it is not outright rent control the way that we thought it was when it started. But I'll defer to Drew too to talk about the guardrails they've been talking about as well.
Yeah, Liz, thank you. You know, and I agree, those are some important guardrails there, but the important thing to keep in mind is this applies only on new development. It has nothing to do with existing housing, and it only applies in those municipalities that choose to adopt an inclusionary zoning ordinance. It's also interesting, a lot of you may not know, but you know, Aspen, Boulder, and Broomfield already have local ordinances that clearly violate the statute, and that this statute was protecting. What we find is that when a local government adopts an unlawful development ordinance, no one's willing to challenge it. They just simply move on from development because that's an added cost that you just can't account for in your development plan. We will see almost definitely in more liberal municipalities like Denver an adoption of an ordinance that says if you're going to build a significant number of multifamily units, that a percentage of those have to be affordable. More than likely it'll be 20%, and more than likely the affordability level they'll require is 60% average monthly income. And that has two effects on development. Either the transaction won't pencil out because of it and things won't get built, or to the extent they can be built, The other 80% of the residents will pay 10% higher rent in order to subsidize the 20% that receive lower rent. It becomes a privatized housing assistance program. You know, that's very bad public policy, because regardless of what you think our joint commitment for affordable housing ought to be, 100% of that bill ought not to be paid for by the working class people that are unlucky enough to be renting an apartment in that same complex. But it is, you know, it's a ship that has sailed, and a concept that's gaining great popularity across the country. I do think it really is not directly tied to rent control, but the same type of non-free market thinking that drives inclusionary zoning schemes also makes people think that something like rent control is a good idea. We certainly are actively engaged down at the legislature, trying to dispel that movement. And I think, at least for now, we've got a pretty good anti-rent control group down there. But we always worry about citizens' initiatives funded by out-of-state interest, because that can be a very, very difficult message to try to dissuade people of.
Thanks, Drew. Did Nate or Vic want to comment? We did have a discussion, and I think Drew kind of covered it, but do any of these bills deal with the Denver proposal to requiring licensing of long-term rentals?
If they're referring to the licensing for landlords,
Yes.
Is that the question?
Yes, that's what Lisa's asking.
Yeah, well, that's already been passed, and I'm sure Drew can probably speak more knowledgeably about this than I can. But it is going to be on a per parcel basis. I think it's going to be as low as like $50 for a single family, and those licenses will be renewed, I think, on a 4-year basis. It's going to require third-party inspections. So that's kind of the main thing that we get concerned about, is sort of both the growth in the bureaucracy of trying to get this stuff inspected, and then also the additional costs, not just of the license, but of hiring someone who is quote unquote certified by the city in order to do those inspections. I don't know if that answers the question.
Yeah, okay, let's see. What is the best documentation to use for leases and evictions? Meaning, I guess, the service of documentation. I always say Drew or Vic to answer that one. Is Vic still on? Okay, well, let's move on.
Well, I can take that. On your leases, there's a couple of things to be careful of. One is, be very, very careful about multi-state platforms, because to a very large extent, landlord-tenant law is a creature of state law. And while there can be some similarities from one state to the next, you run the risk of having a lease that's dumbed down to whatever the most restrictive state is, and you may tie yourself into knots that you don't necessarily have to tie yourself into in Colorado. The other thing is, a licensed real estate broker, remember your requirements that all your transactional documents either be real estate commission approved, and there is not a commission approved lease, or that you have those documents reviewed by an attorney with the disclosure requirement of who reviewed that and on whose behalf be printed on the document. And I think most of the people in this line are fully aware of those requirements, but we occasionally get someone that's just dabbling in property management that doesn't think that part through. As far as the demands and the notices to quit that you actually serve on the property, even the Colorado Department of the Judiciary post sample forms for those on their website. And I always encourage practitioners to use the official forms rather than drafting their own that complies. The official forms are recognized by courts quite easily as what they are, and sometimes your own documents get much greater scrutiny because of that.
Drew, I
Yeah.
think this is directed to you too, so don't mute yourself. So Pat asked, so what is the plan for switching out heating, cooling systems to using something other than natural gas? Older homes with boilers and existing homes with gas force air, all gas consumers.
Well, none of that is touched by the initial citizens initiative, other than your use of gas is going to be heavily taxed to the point that you'll have this economic incentive to switch to the electrical grid because of that. There are many things afoot in various formats that will attempt to require retrofitting from gas to electricity. The energy benchmarking bill, which I don't think got discussed on the state review, it only applies to large buildings, 50,000 square feet or above. But it basically, if you boil it down to its nuts and bolts, says 75% of the covered buildings in Colorado will not be compliant, and all non-compliant buildings will have to pay a $365,000 a year fine, which is a pretty strong incentive to switch over to electricity. And I saw Lisa's comments in the chat room that took some offense to my anti-environmentalist comments. Let me first say, when I use the term we, I simply speak for the Colorado Apartment Association. I certainly don't mean to imply I speak for anybody on this Zoom call. But the things that get lost by the zealots on the other side on this are twofold, really. Multifamily housing represents the greenest possible housing option that's out there. And that's not because we're necessarily wiser about it than anybody else. It's just a reflection that there's common walls, common floors and ceilings, lower square footages, and all those lead to creating far less carbon by living in a multifamily environment than a single family environment. And so many of these proposals, virtually all of them, focus on creating a cost for multifamily that does not exist for single family, and therefore it economically incentivizes people to move from less efficient housing to more efficient housing, and that's bad. The other thing that it does is it doesn't norm for occupancy. And if you think about the carbon initiative in Denver, it's a perfect example. It gives an allowance of a certain amount and then charges you more money once you exceed that allowance. Well, what's the primary thing that's going to make you exceed that allowance? And the primary thing is being poor and being forced to house a lot of people in a small amount of square feet. If you have 6 people living in a 2-bedroom, they open the refrigerator more, they cook more meals, they charge more iPhones. All those things make you use more energy, and these things become a horribly regressive tax on those that can least afford it. And, that's just a problem with the math and the formulas, but folks that are chasing simple ways to reduce carbon invariably end up pushing people away from more efficient and greener options.
So Aaron's asking, and this goes back to the recycling composting, what does someone do if there's not room on site for that additional recycling and composting?
Well, and that's exactly been one of our problems. The Denver has been, on the one hand, wanting to promote recycling, but on the other hand, very hostile to land use that requires greater usage of the land for trash containers. And imagine when you're talking about things like a high rise that has pre-existing trash chutes that doesn't allow for things like composting. As a practical matter, many of our members switch over to a very expensive valet trash collecting system to try to accommodate some of these added requirements. But it does greatly increase the expense of both complying with recycling and composting. I suspect what we'll find as this rolls out that the city will just be forced to, frankly, be a little more friendly to allowing you to locate a composting facility or a recycling facility, but it certainly in some application becomes a very, very difficult physical space item to manage for a property manager.
So John,
It does provide right now for 1-year exemptions based on certain hardships. So that may be extended, or that might be a consistently extendable thing, but it again might still require action on the part of landlords in order to qualify for that exemption as often as the city requires.
Yeah, and that's a frequent talking point of the advocates for these things. You point out a problem, and so they kick the can down the road by a year and say, look, it's problem is solved, but obviously 2025 is going to eventually exist and will be a problem that has to be dealt with.
right. So John and Ashley had the same question on the Denver licensing. If you own 3 properties in an LLC, but have multiple LLCs, how do they determine the 10% of inspections?
Well, some of the detail of that remains to be seen in the rulemaking process. They define the license as being required per parcel now. And, one of the things we want to be careful with is they don't just decide parcel means tax parcel, because you can imagine there are condominiumized buildings out there where there's one building, but 150 different tax parcels to assist in the sale of those units if they ever are condominiumized and sold off. A person could at least theoretically end up having to have 150 licenses for that building. And it's very akin to licensing your plumber by the sink as opposed to by the plumber. But there will be applications out there where even if you're a very small operator, you'll be held to have multiple license requirements here. I think it will, as a practitioner, and it's a little bit early to see how this plays out, but you're always in that position of deciding when you're a third-party manager, whether you want to write those leases in your name or whether you want to write those leases in the name of the ownership entity. And I suspect there's going to be more pressure to write leases in a common name in order to try to claim that they all fall under a single license as those definitions get developed.
So I just want to answer this one real quick, or just clarify. Littleton is in Denver County, so doesn't matter what city, as long as it follow up underneath Denver County, it's covered by that licensing requirement, correct, Nate?
Yes, I believe so.
Okay. Let's see. When it comes down to licensing, it doesn't matter if it's landlord, rented, manage, or property manager, correct?
No.
Okay. Have any of you guys heard any talk about licensing both long-term and short-term rental property managers?
There's nothing on my radar in regards to that. I don't know.
Let's see. Sorry, I'm just trying to get caught up. Let's see. Why are the laws of supply and demand, supply not allowed to control rents? Who wants to jump on that one?
I mean, there's an aspect to which housing is a public good, and obviously an aspect to which there are various aspects of the way that markets are structured that have to do with government. Every part of our economy is structured to some degree by the ability to hold people to contracts and laws. So when we look at this stuff, we're always looking at the correct balance of intervention in terms of government. And so I think especially with COVID this year, housing has really become much more of a stressful issue for people. And then also with the incredible appreciation of home values and property values here in the Front Range and the growth. I mean, it's an issue of public concern. And the truth is it's always going to be that way. And it's never not been that way, but rents have never been completely determined by supply and demand. They've always been affected by zoning. They've been affected by infrastructure, by property taxes, all that kind of stuff.
So if a realtor is also an attorney, is there any problem with the broker attorney writing the lease or other documents? Because you know how we're supposed to have ours property management agreements and our leases done by attorneys. So I guess if that property manager who's also realtor is also attorney, does that mean, maybe that's a Drew question?
No, there's not a problem with doing that, but I'd still follow the disclosure requirements. Let's say you're writing the leases in XYZ management company and you're Joe Schmo attorney. I'd still have the disclosure on there that this lease was reviewed by Joe Schmo as a licensed attorney for the benefit of XYZ management company, even though in reality, they're all the same people.
Okay. Let's see. So the tax on carbon, have you answered this one already, Drew? Has the tax on carbon is not for single family, just apartments, correct?
That's correct. It only applies to multifamily and commercial users. Now, that's not because the advocates wouldn't like to have the same provisions imposed upon single family. They just recognize, or actually, no, I'm misspeaking. I'm confusing my Energized Denver stuff in this initiative. On the carbon tax piece, the tax on natural gas usage, that will apply to all natural gas users. The allowance changes up a bit between multifamily, but that's going to be a user-wide tax.
Okay.
Sorry to go down the wrong path on that.
Brent, I'm pretty sure, I understand Littleton is in 3 different counties, so it would be the home that the actual county that it sits in. So if it's sitting in Denver County, even though it's Littleton, it's still going to follow up underneath the county rules, correct?
You know, that is a highly technical question. You know, at the fringes, of Denver, you do have a few places that aren't in the municipality of Denver, but are in the county of Denver. And I frankly don't know on the fly whether or not, say, Littleton's municipality trumps things that the county does on the countywide level. It doesn't affect much, but what it does affect becomes an extremely complicated question.
I do want to ask this last question. Do landlords have to pay for bed bug remediation when the tenant brings them in? Tenant living in a property 3 to 4 years and they show up, that cannot be fair and no evictions. This is retirement income for many of my clients. So basically there was the bed bug bill that passed rather quickly. They snuck it in really fast and went through. Doesn't matter how the bed bugs got there. It is the responsibility of the landlord to take care of that bed bugs.
Yeah, and I would say, practically speaking, it's just not worth it. There's no way you're going to recoup the effort you'd have to go through, and similar in some ways to drug use. I mean, you'd have to directly observe them bringing bed bugs into the building. Then you'd have to go to court to pay for that. In the end, I would say, from a practical property manager standpoint, your goal is to remediate that as quickly as possible. And if you can, use that treatment period as an excuse or as an opportunity to get that tenant out of their lease, whether that's a cash for keys situation or whatever it is. What we typically do is we say, look, we can't remediate this with you in the unit, and find a way to hopefully have language in the lease that lets you exit them and just move on. It's not a great situation, but they're bed bugs, so they're awful regardless.
Well, we are at 11:01. This has been great panel. I'm sorry if I didn't get your question, but I tried to get every question read in the chat. And then a few that when the survey went out, there was a few questions and I tried to hit some of those. I'm not seeing any extra questions. So I would just like to thank everyone for today's session. And I would love to thank our speakers, our amazing speakers. And if anytime you guys have any questions about leases, what should be in a lease, Drew and Vic put their website, definitely go on their website. If you have any questions about the CLLC or NARPM, feel free to reach out to Danielle or myself. We would love to give you more information. Course legislation, Liz is all over it, and I can tell you she does an amazing job. You saw Aaron, he spoke out a little bit on here. Aaron and myself is on CARS LPC. We're both on the housing subcommittee. And I can tell you that CARS legislative is working hard for our housing needs. So thanks again for joining, and you guys have a great weekend.